I now call case number 116167, Helen Lori Knoll versus Olathe School District number 233. Before council approaches the lectern, I did want to remind you of the musical chairs that we were going to be performing this morning. You've just witnessed one of those. Rejoining us is Justice Beyer to my left. Leaving is Justice Lukert, but she's being replaced by the distinguished looking jurist to my right. This is the Honorable William Mott. He's the Chief Judge of the 30th Judicial District sitting in Wellington. As Judge Gehring earlier this morning, he has read all the briefs in this particular case, and he'll be sitting on the next two cases today, and he will be participating fully in the ultimate resolution of all of those cases in our case conference this afternoon. So Chief Judge Mott, on behalf of my colleagues, I'd like to thank you for helping out the Supreme Court on these cases.
Thank you. I consider it an honor. Thank you.
Thank you. Counsel?
Justice, I would request 5-minute rebuttal.
5 minutes are granted.
For the purpose of the people watching, this is a workers' comp case that the administrative law judge and the workers' comp board ruled in favor of the claimant in this matter. This gets to KSA 44-523F, called a motion for extension. This was then appealed by the respondent to the Court of Appeals. The Court of Appeals reversed the findings of the ALJ and the Workers' Comp Board. I'm going to try to be very brief. I would incorporate my brief that I submitted for your review. We have two decisions, one called Welty that has been cited, that says 44-523F is substantive law, and the decision came down in 2012. My client, who is an Olathe school teacher for special emotionally charged students, had her accident in 2009. We filed our application for hearing in 2011.
Don't you see a distinction with Welty in your situation here? The Court of Appeals pointed it out. It seems pretty obvious. In Welty, there was an extinguishment of an established right in that there was no time period in Welty. Here, there was an established time period, and in fact, that time period was amended prior to your even filing this action. So isn't that a huge distinction between Welty and here?
And I don't want to get into argument with justices.
Well, just tell me why it isn't.
Yes, here's my point. I put an example in my brief, and I think that's at page 8. And that is an example if the person had had an accident in 2007 or 2008, and you filed an application for hearing, and by the time the law went into effect on May 15, 2011, if you had not filed the motion for extension, they're gone. That's a substantive right in my mind as far as losing
that isn't what happened in Welty or here.
Well, Welty is a case that found that you apply the law that's in effect at the time of the accident. And in Welty, their accident, I think, occurred in 2003 or 2004, and they've found that the law should apply.
There was two factors in Welty. One, the timing of the accident, but also what law was in place at the time the case was filed.
Yes.
Those are two factors. Here, we don't have that. Here we have the law that was in place when your action was filed is the 2011 version of the statute.
Yes, and
you don't think that makes any difference?
Well, my argument is Welty found that 44-523F is substantive, and you apply the law that is in effect in the time of the accident. My point as far as Knoll, I think the Court of Appeals made the wrong finding because I think it is substantive also because it kicks you out of court. I'm hoping, okay.
And just to clarify, I think my colleague made the point, but when the application was filed by Ms. Knoll, the law had already been changed to 3 years.
That is as far as the 44-523F.
So all we're talking about is when she filed that application, whether she had 3 years or 5 years to get it completed without an extension.
Justice Johnson, I agree with what your comment is, but I think for a lot of us, we're out there representing people. We took the Weldy decision to be the law that whatever at the time of the accident would be in place. And I think that's how we all construed the law.
And it wasn't just the years. The prior law was automatic extinguishment after 5 years. The 3 years allowed for a motion to extend, right? I mean, weren't those different?
Well, I think under the 2006 amendments, it was 5 years.
Okay.
And maybe I
Okay.
need to
All right.
review,
It
but
was-
you
it
could
wasn't the-
file a motion for extension.
Yeah, exactly. It
Yeah.
wasn't the motion, the ability to file a motion that changed, it was the hearing, automatic hearing on one, right?
Correct.
Okay.
One of the other things, and maybe come back to Justice Rosen's question, if you apply the law as Knoll did in this case, and saying it's procedural, then you change the law that should have been in effect for this lady for 2009, and you reduce her substantive rights from 5 years to 3 years to show just cause, or good cause, not just cause, good cause, why you should have an extension.
It's reduced, but you know about the reduction prior to even filing the case. It didn't really abolish a right, it changed it procedurally.
I would agree with that comment. It changed it procedurally, but I think everybody was operating under the assumption that this was substantive law based upon the Welty decision. I think, and I'm going to come back to my example I gave, that in 2007, if you'd have filed an application for hearing, law goes into effect, 3 years have elapsed, you're out of court. I mean, it just summarily knocks your case out if somebody files a motion to dismiss.
Say that again? That's not true on a 2007 filing, is it?
No, that's my example in my brief. That's what I'm trying to point out. So, in other words, if you had filed an application for hearing prior to 2011, and your 5 years haven't elapsed, but 3 years have, then you're out of court. And to me, that's substantive. I think at page 8 and 9 of the Knoll decision, it discusses, I think, kind of the heart of what we're here before the court. And it talks about the general rule is you apply the law that was in effect at the time of the accident. And then I have a little difficulty understanding the reasoning of the Court of Appeals going from substantive law to procedural law, but I believe that was inaccurate. We also cited a different decision, the Bryant decision, and in the Bryant decision, that was trying to apply the standard prevailing factor, and prevailing factor came into the law on May 15, 2011. This was an accident occurring before, but it was decided after 2011, and the court in Bryant says, again, you apply the law that was in effect at the time of the accident.
You initially, in your, it's somewhere along the way, you argued that the 2011 statute, the amendment, doesn't create a time bar, but you abandoned that claim? Or you didn't argue that?
We didn't argue that because it really didn't come up. I've had the opportunity, I know the next case you have in front of you is a Glaze decision. I've had an opportunity to review their petition for review. I agree with their position, but we...
What happens in your case if we agree with that position? Not simple, we don't know where we're at, but what happens in your case when you didn't argue?
Well, it wasn't, to be honest with you, I don't know, because I've thought about that. I thought about it on the way over, what would happen. I'm not sure.
Okay.
I have no further argument unless there's questions.
Do we have any more questions? Thank you, counsel.
Thank you.
May it please the court, Kip Cuban appears on behalf of Olathe School District, Unified School District 233. The court's faced with a very narrow issue today, and that is whether or not the amendments made in 2011 to KSA 44-523F are procedural in nature or are substantive in nature. And it's the position of the school district that the Court of Appeals got this decision correct. The timeline in this case is very important. Again, the first version of KSA 44-523F was passed by the legislature in 2006. And the Court of Appeals has recognized in the Welty decision that the reason for that was basically remedial in nature. There were a number of stale cases that were in the system, and they were trying to establish a procedure in which the court could work through this stagnant backlog of cases. And they came up with the procedures in KSA 44-523F to address, maybe not going forward, but to address and prevent those backlogs from getting larger. And that is the first time that statutorily there was established a procedure to dismiss a workers' compensation case under the Act.
So you'll agree that the legislative intent was to, in adopting this, was to ferret out the stale cases and to dismiss for lack of prosecution, rather than to be a trap for the unwary.
I don't think it's a trap for the unwary unless you don't read the law books.
But in this case, there's no allegation that it was the lack of prosecution, or we don't. Well, I don't know. Do we know whether she's reached maximum medical circumstance?
I don't have that citation in front of me in the record, but the record established that she was released by her treating doctors a substantial period of time prior to the case coming on.
So you're saying this does fit the intent, this particular case fits the intent because it was a lack of prosecution rather than waiting for maximum medical recovery.
Right. She was at maximum medical improvement for quite some time prior to the hearing.
So that I was going to. There's no showing that Ms. Knoll had good cause to extend her claim.
In my view, there was no showing of good cause.
I would note, but there really was never an opportunity for her to present that.
Well, we did have a hearing on the motion to dismiss, and the court had a hearing on that motion, and the court determined that it was not going to dismiss it, but it based its decision on the Welty decision, saying it was substantive and not procedural. So, as far as the merits, it was not decided.
It was within the time period, so there's never really been a merits determination on the good cause. Okay.
Now there was a financial.
Counsel, let me just make sure I understood what you said a moment ago. You said that there was evidence in the record before us today that she was at maximum medical improvement well in advance of the hearing on the motion to dismiss. Right?
Yes,
that's
I think
the hearing you were referencing.
I think if you look in the regular hearing transcript, and as I recall, the treating doctor, it might have been Dr. Bailey. I mean, I'm sorry, I didn't.
That's all right. I just wanted to make sure I understood what you.
But yes, she was at maximum medical improvement and eligible to try her case for some period of time prior to that. Now, there would be an economic advantage as to the law at that time for her waiting until she retired from the school district to try her case, because under KSA 510 subsection E, this would have been a work disability case if she is not working. As long as she's working for the school district, she only qualifies for functional disability. But if she retires and then tries her case, under the law at that time, she's not earning any wages, so she gets an enhanced benefit by waiting until she retires to do that. So there was an economic benefit for her to wait, but there was no legal or reason for her to wait. I do want to address the example that Mr. Shetler raises. I disagree with him that the amendments in 2011 create a Sophie's choice for the claimant in this case. They did reduce in the amendments in 2011, they did reduce the time period in which they could pursue the cause of action or the claim from 5 years to 3 years. But upon filing that application for hearing, the claimant still has 3 years at a minimum to pursue those rights. And all they need to do to extend that is to file a motion within that 3-year period to request additional time and have an opportunity for a hearing to show good cause. The practice now is for claimant's counsel or the claimant, when they file an application for hearing, is to simultaneously file a motion for extension of time to ensure that that motion for extension of time is on file within that 3-year period. There was nothing that prevented the claimant in this matter from filing that motion within 3 years or within 5 years of the date of the filing of the application for hearing. In fact, the filing for the motion for extension of time did not even occur until after the motion to dismiss had been filed in this matter.
Say that again. So the practice now is upon filing of a case, there's a filing for an extension simultaneous with the filing?
Correct.
And
My experience.
Okay.
And that's been since the inception in 2006 of the 5-year establishment of the rule.
So you'll concede that the timing of the filing of the motion for extension really has nothing to do with the rationale behind the rule or reality. It's just a pro forma.
Well, I don't think I would go to that extent, Justice Johnson. I mean, there's a reason. The legislature has established a reason for a time period to begin with, and then for a 3-year time period.
As a practical matter, if it's pro forma, I don't understand what the prejudice would be to your client that is filed 3 years in 1 day, or if it's filed on day one.
Well, and again, work comp is a little different because this court has been very clear in saying that you look at the statutory language and you apply the statutory language. You don't really consider the reasoning behind it or the legislative history or the rationale the legislature may have had, because it's a strict construction of these statutes. So we can get in and discuss about pro forma and legislative intent, but this court has usually shied away from that type of discussion in regard to these issues. So I guess in summary, the Court of Appeals did get this right. The Welty case is not applicable. It's not an abandonment of prior decisions of this court. I think the Court of Appeals correctly distinguished that we're not talking about the 2006 enactment of 523F. We're talking about the 2011 amendments to that action, and those were found to be procedural, which is consistent with this court's prior rulings in both the Harding case and others, even in the workers' compensation realm, that when it's procedural, it's retroactive, and when it's substantive, it applies prospectively.
Is this even retroactive at all? In other words, you only have to ask, is it procedural or substantive if you have a retroactive application?
Now, that was the ground that I argued in front of the Court of Appeals that they rejected, but I could renew that now, that really the triggering mechanism of the statute is the filing of the application for hearing. And that filing for the application for hearing was done after the 2011 amendments. The Court of Appeals rejected it. I still think that that's a valid criteria for this case.
You would just say it's a procedural change and it applies to proceedings that haven't occurred yet.
Correct.
That's basically what you're saying. It's really not even a retroactive analysis, just something that applies. The rules have changed prior to the filing, and
That was my first analysis in the brief to the Court of Appeals. They discussed it, they didn't like it, they went with the second ground. If there are no other questions, I have nothing else to add.
I see no more. Thank you, Counsel.
Thank you.
Are you ready? I'm going to try to be brief. One of the things, and I know there's other cases behind mine beyond the Glaze case on this issue. The intent originally was to get rid of stagnant cases. The problem with this case and all these cases that flow out of 44-523F, many times we're litigating and we're going before the court. I think you're going to hear this in the next case, getting medical treatment, getting TT, but because somebody didn't file that motion for extension, even though we were still working the case, that should eliminate.
that isn't what we have here, though, is it?
No, it's not, but I'm responding to his argument a little bit. The second thing from his argument was that she had hip replacement surgery, total hip replacement surgery by Dr. Scott Cook. We were actively, post when she finished being MMI, we got our rating reports, and then we were doing depositions about a year and a half after that surgery. And the economic advantage, I disagree with that. I don't think that's been argued in any brief. For the fact is that because of her still having difficulty with the complications from her hip surgery, she elected she just couldn't do it again anymore, especially working with emotionally charged students. The other thing, this was set for regular hearing. Regular hearing, and I had to pull out, was held in July 23rd, 2015. It was set prior to that, and then the motion to dismiss was filed by Mr. Cuban, and then we had to deal with that before the regular hearing. So it wasn't like this was a stale case and nothing was being done about it.
When was it set? When was it set for regular hearing?
I don't have that. I think it's probably in the record submitted, and I apologize to Justice Rosen, I'm not sure, but it would have been set sometime prior. I'm going to guess.
Prior to the filing of the motion to dismiss. Is that what you're saying?
Right in that same time period. Any other questions?
I see none.
Thank you, and I want to thank you for granting the petition for a review in this matter.
I thank both counsel for your arguments this morning. Clerk will take this matter under advisement. This time the court